I'm happy to facilitate this. We are very lucky to have a good lineup of distinguished presenters and opinion shapers. When you talk about the AU reforms, at the high table I have people who have engaged with the AU since the OAU days. So when we talk about reform, they will be giving us views that are grounded on not just the knowledge that they have, but also how the transformation of the organization of African unity changed to the African Union, and why the reforms are important. We are sitting at a space which is getting a bit confusing with a lot of unconstitutional changes in government, and so a human rights perspective becomes very crucial. As you may know, the AU reforms were kicked off by a head of states and government's retreat that was held in Rwanda, in Kigali, at the margins of the July summit in 2016. And from that time, it has been closely rolled out with a lot of supervision from the AU organs. Subsequently, the process has been implemented in some of the AU organs, starting with the African Union Commission, and now it has reached the level of other organs. So in the last retreat in Kigali, in July, the issue of the reforms of the African Union organs, particularly of the human rights organs, was a subject matter. And so I would like some of the panelists with us who are following that process closely to share with us their reflections on where we are on the reforms, and actually what civil society would like to recommend to us, the AU, because we are inside the family. We'd like to hear from the civil society on this process moving forward. We envisage that the reform team will present a report to the February summit according to the roadmap. And so between now and February, we believe that any views that would come out of an AU organ would maybe find space in the final report. So without much ado, allow me to introduce my panelists. I have with us, starting from my left, far left, Ms. Hannah Foster. Hannah Foster is known to all of us. She's going to be answering a question that I'm going to pose on her. I'm going to ask Anna, what does the African Commission mean to African citizenry? And what mandate should it serve? To my immediate right, I have our brother Ibrahim Kane. I'm going to ask him to reflect on the reforms process of the African Union rights architecture. Next to Khan, I have Advocate Don Dare. I'm going to ask him to talk about an accessible, independent, and effective African court. Mr. Khan, when you take the floor to talk about the African Union, what African Commission means to citizenry, I think you should combine it with the second perspective that we would like to hear from you, that is a possible cure for complementarity between the African Commission, the African Court, and the Committee of Experts on the Rights of the Welfare of the Child, because we don't have much time to give you the floor twice. So segment your presentation in 2 moments. And then lastly, I'll be asking our friend from Amnesty International, Dr. Jaffet, about how effective let me start again. How CSO engagement with the African Union Commission has been effective, reflecting on ECOSOC. So let me start by giving the floor to Madam Anna Foster. You have the floor.
Thank you very much, Commissioner Lita, for giving me the floor. The African Commission on Human and People's Rights, established by the African Charter, is the body that we all know and respect as part of the citizenry, and I want to express the opinion that the setting up, as set up in the African Charter on Human and People's Rights, all of us believe that the African Commission should be effective, should be open, and be able to grant each and every citizenry that recourse, that redress that they seek. And what we have seen is the African Charter, according to its mandate in Article 45, promotes, protects, and interprets the Charter. And according to information, it is being lulled that African Commission should be stripped of its interpretative mandate. And the interpretative mandate of the Commission is very important to each and every citizen in Africa. And we feel that it's something that needs more attention. The court is supposed to complement the Commission to determine these complaints. And it is different. Today, the African Commission is open to every citizenry who does have a complaint. But then access of citizens to the court is very limited to states that have signed Declaration 1334, Article 34.6, which is problematic. We also know that the African Commission jurisprudence has enriched that of the court. And anybody can file a case at the level of the African Commission. This is what the citizenry need. I remember when the Commission met in Togo, there was this gentleman who had sent his case to the Commission and could not travel to the court, to the African Commission session in Banjul. So it was when the Commission met in Togo that he had the privilege to meet the Commission and to also ensure that his case was dealt with. But this would not be possible anywhere else in any of the organs of the African Union. So the accessibility of the African Commission is one of the things that definitely endears it to the citizenry. Two, that of access to civil society. There's a resolution with the criteria for granting observer status to NGOs. This is one of the most accessible points, because when you look at the criteria, it grants observer status to them. It's not interested in their source of funding. You just need to indicate. But then, according to what is being proposed, you find out that there is even an indication of what percentage the membership of the organizations should be able to provide. This is very difficult and ironic, considering that when we look at the budget of the main organ, about only 28% is funded by them. The rest is funded from outside. And then you also look, even when you look at the peace and security budget, only 2% comes from the main organ. The rest comes from partners. And yet, non-governmental organizations are expected to be able to bring out over 2/3 of the resources that they use during the year. this is something that will not endear the African Commission to its citizenry, because there is need for us to ensure that we have a commission that has a listening ear and could make sure that it listens to the citizenry and the NGOs, because the NGOs are one of the primary partners of the Commission. So to align the criteria for granting of observer status of the African Commission with that of the ECOSOC could create challenges, because CSOs do not have that money amongst themselves. And it is also disturbing that the NGOs are expected to be able to meet the requirements. So that could be a major impediment to that of to the NGOs. Then there is also the need of preparing a code of conduct. The code of conduct is also likely to undermine the activities of the African Commission, because one would expect that an independent and impartial group of experts know what they have been mandated to do and should be able to meet their obligations. So perhaps when we look at the need or the call for a code of conduct for the African commissioners, I think that also could be an area that would not endear the Commission, that would not give us the effective Commission that we seek. There is also the need for us to look at, in 2015, we did have challenges. And that was when the African Commission granted observer status to CAL. And we still find out that there are challenges in terms of when we talk about sexual orientation and gender identities. The Charter talks about all human rights to all its citizens. But are we sure that trying to ensure that certain groups of people do not have access to membership or being granted observer status is the way to go? Perhaps these are things that we need to put into consideration as we look for the African Commission that we, the people, want. Constraining the work of the Commission would not definitely assist in this endeavor. I want to ask ourselves, is our role to enhance or to constrain the work of the African Commission? I think whatever would erode the work of the Commission should be avoided, because then it would undermine its independence and mandate. And we should really be able to stand up and interrogate some of these issues that are put on the table. Thank you very much.
Thank you very much, Hannah, for that reflection. I think I go now back to my brother, Mr. Khan. I would like you to reflect on the AU reform process for us. Maybe take 6 minutes for this, and then we see how it goes, and then we see whether we should actually not bring Don in between and give you the floor again. Because I think, yeah, if you can combine, we'll be very happy. The floor is yours.
Merci, Madame la Présidente. Merci à la coalition pour avoir organisé cette activité qui nous met au cœur des problèmes que connaît le système africain actuellement. De façon générale, tout système, toute œuvre humaine a besoin de temps en temps d'être revu, d'être amélioré et de le rendre plus fonctionnel. Lorsqu'il s'agit de mécanismes de droits de l'homme, l'Afrique n'a pas été le premier continent à en avoir. L'Europe en a eu. L'Europe a reformé son système pour le rendre plus efficace au fil des temps. Il y a eu plus de 6 ou 7 réformes réformes de fond au niveau du système européen. et même le système international des droits de l'homme, qui est le plus complexe parce que concernant le plus d'États, le plus de traités, le système onusien a connu des réformes. Il y a eu 2 réformes de taille au niveau de ce système. Et donc, tout cela pour vous dire que l'Afrique ne pouvait pas aussi échapper, dans le cadre du fonctionnement de son système des droits de l'homme, à un effort de rationalisation, aussi à un effort pour le rendre plus effectif, pour le rendre plus efficace. Parce que en 35 ans d'existence, la Commission africaine permet aujourd'hui, avec son expérience, d'identifier un certain nombre de goulots d'étranglement auxquels il faut trouver des problèmes. La Cour africaine est encore plus jeune, elle n'a même pas 20 ans d'existence, elle l'aura dans 2 ans, je crois, 3 ans, et tout cela permettra aussi de trouver des solutions aux problèmes qui se posent au système. Et quand je dis le système africain de droits de l'homme, je ne me limiterai pas seulement aux mécanismes, la Commission africaine, le Comité africain sur les droits et le bien-être de l'enfant, la Cour africaine, mais le système est aussi composé de cours régionales, la Cour de la CEDEAO, la Cour de justice de la Communauté économique des États de l'Afrique de l'Est, qui n'est pas très loin de là où nous discutons, le tribunal de la SADC, ont été aussi des mécanismes qui contribuent au bon fonctionnement du système africain des droits de l'homme, parce que fondamentalement, le premier texte qui est appliqué par tous ces mécanismes, c'est la Charte africaine des droits de l'homme et des peuples. Et comme vous le savez aussi, tout système de droit a des systèmes juridictionnels, mais aussi a des systèmes d'ordre administratif et politique qui sont chargés d'aider à la mise en œuvre et d'une manière ou d'une autre, faciliter les relations entre les États et le mécanisme. Alors, s'agissant du système africain, ce n'est pas la première fois qu'on a entendu parler de réforme du système africain. Il y a eu beaucoup de tentatives par le passé, mais ces tentatives ont souvent échoué par le fait, et je pense que c'est nécessaire de le souligner, que les réformes concernant les mécanismes de droits de l'homme doivent être des réformes bien pensées, dans la mesure où souvent ces mécanismes ont pour origine des traités. Or, si l'on veut réformer le mécanisme à partir du traité, ça prendra énormément de temps. L'exemple européen nous montre que parfois, pour arriver à faire adopter un traité additionnel, ça peut prendre plusieurs années. Mais l'expérience onusienne nous a montré aussi qu'on peut ne pas toucher au traité et faire en sorte que le système lui-même soit amélioré. Donc, je situerai les efforts de réforme du système africain entre cet extrême qui est le système européen et l'autre extrême qui est le système onusien de réforme des droits de l'homme. Alors, quel processus le système africain a suivi? Alors, il a suivi un processus pas linéaire, mais un processus plus ou moins alambiqué. Parce que, comment ça a commencé? Ça a commencé avec la réforme de l'Union africaine elle-même. Vous vous rappelez que en 2016, le président Kagame a rédigé un rapport sur la réforme de l'Union africaine et le sommet de janvier 2017 a adopté ce rapport et ça a été la feuille de route pour la transformation de l'Union africaine. Alors, dans son rapport, le président Kagame soulignait que l'Union était confrontée à 4 défis principaux. Elle est fragmentée en tant qu'organisation et compte trop de domaines d'intervention. Sa structure est complexe et sa capacité de gestion est limitée, ce qui entraîne des méthodes de travail inefficaces, une prise de décision médiocre et un manque de responsabilité. Troisièmement, que l'Union n'était ni financièrement indépendante, ni autonome, et dépendait plutôt du financement de ses partenaires pour une plus grande partie de son fonctionnement. Et en dernier lieu, qu'il y a vraiment presque pas de coordination entre le centre, qui est l'Union africaine, et la périphérie, ou les régions, si je vous dis, qui sont les communautés économiques régionales. Alors, dans toute cette conversation, on n'a pas vraiment ciblé les mécanismes de droits de l'homme. On a parlé de l'Union en général. Mais dans le rapport de 2017, de janvier 2017, on ne consacre pas aussi une attention particulière aux droits de l'homme. On se contente seulement d'indiquer dans le texte, et je cite, que les récents travaux de l'Union africaine se sont concentrés sur la consolidation des institutions, de la culture démocratique, de la promotion et de la protection des droits de l'homme, y compris des droits des femmes. Et on a fait 2 brèves références à la fusion entre la Cour africaine des droits de l'homme et la Cour de justice. Après, on n'a rien dit. Mais quand on parle des observations sur la promotion et la protection, on pense que cette observation s'applique dans une certaine mesure au système africain des droits de l'homme, c'est-à-dire aux organes, aux méthodes de travail de ces organes, à la question du financement de ces organes et au manque de coordination entre ces organes, c'est-à-dire les cours et les autres institutions de défense des droits de l'homme. Alors, dans le processus, l'Union africaine a aussi proposé, dans le rapport de 2017, qu'il y ait, dans l'évaluation de l'efficacité des organes judiciaires et quasi-judiciaires, un certain travail qui vise à, d'abord, un examen des rôles, mandats, fonctions, pertinence et efficacité des organes judiciaires et quasi-judiciaires de l'Union, d'élaborer des recommandations sur les rôles, mandats et fonctions, ainsi que la pertinence et l'efficacité des organes judiciaires et quasi-judiciaires du point de vue du mandat et de l'efficacité, et enfin, élaborer des propositions pour la restructuration et les besoins en personnel des organes judiciaires et quasi-judiciaires, élaborer un budget et un plan de mise en œuvre de ces recommandations. Alors, l'idée ici, c'était vraiment dans le cadre de la réforme de l'Union africaine, de voir comment, et ça j'insiste beaucoup, comment les 3 organes des droits de l'homme peuvent travailler plus efficacement et remplir pleinement la mission qui leur est confiée. Alors, quand on regarde de près tout ce qui a été proposé, on peut dire que pour ce qui concernait les mécanismes de droits de l'homme, il y avait au fond 6 choses importantes à faire. La première, c'était de réfléchir à la manière de renforcer la cohérence du système des droits de l'homme de l'Union africaine en examinant les mandats des organes de défense des droits de l'homme, étudier les moyens d'améliorer leur coordination afin de répartir plus clairement les tâches entre les organes de défense des droits de l'homme et d'éviter les doubles emplois ou chevauchements d'activités. Juste un petit commentaire sur ce point. Ceci est exactement ce que le système international au niveau des Nations Unies a effectué. Il y avait énormément de mécanismes, 8 organes des traités, 9 même, si on ajoute le sous-comité. Mais ce que les Nations Unies avaient essayé de faire, c'est de voir comment ces organes, on pouvait, en les mettant ensemble, faire en sorte qu'il y ait moins de dépenses, mais qu'il y ait plus d'efficacité dans le fonctionnement de ces organes. Et comment le Haut Commissariat aux droits de l'homme pouvait travailler en étant le secrétariat de pratiquement tous ces organes et faire en sorte comment ça fonctionne. Donc, cette question, elle est importante et on a un exemple de mise en œuvre de cette question. Deuxième question, c'était d'examiner les méthodes de travail, la dotation en personnel de ces organes de défense afin de les optimiser, c'est-à-dire étudier la relation entre les 3 organes de défense et les principaux organes de l'Union, en particulier le Conseil et le Conseil exécutif, la Commission de l'Union africaine, le Conseil de paix et de sécurité, revoir l'architecture de la gouvernance de ces mécanismes et examiner aussi les décisions des États et des organes de l'Union qui ont une incidence sur les travaux de la Cour électorale. Là également, ce n'était pas une chose très difficile à réaliser si on se base sur la manière dont, à l'international, on a essayé de régler les problèmes de ces mécanismes. Par exemple, rien n'empêche de faire en sorte que, puisqu'on ne peut pas ou on peut difficilement reformer les traités, faire en sorte que si on prend les 11 juges, les 11 membres de la commission, les 11 membres du comité des droits de l'homme, on a déjà 33 Africains qui s'occupent de questions de droits de l'homme. Et ils ont un personnel. Et comment on pourrait travailler pour faire en sorte que le personnel qu'il y ait un personnel, je ne dirais pas totalement unique, mais un personnel pratiquement commun entre ces mécanismes-là, en tenant en compte les spécificités des uns, parce qu'une cour a un greffe. Mais comment faire pour qu'on puisse les mettre ensemble, leur secrétariat, et faire en sorte qu'ils puissent fonctionner? Ça également, c'est une solution est possible. Des actions, des initiatives sont possibles pour pouvoir y arriver. Troisièmement, réfléchir sur des mécanismes de financement. Les mécanismes de financement, c'est là le cœur du problème. Actuellement, le système qu'on a au niveau de l'Union africaine en ce qui concerne les droits de l'homme, c'est un mécanisme qui est unique, il faut le considérer. Il y a ce qu'on pourrait appeler les enfants gâtés du système, comme la Cour, et ce qu'on pourrait appeler les enfants honnis, comme la Commission et le Comité. Comment peut-on imaginer une commission africaine qui couvre 54 pays avec un budget de moins de 1 million? Comment peut-on penser à une Cour qui, en principe, ne fonctionne que grâce au mandat qui lui est donné par 8 pays et qui peut fonctionner avec plus de 7 millions? C'est unique. C'est unique pour le système et ça ne permet pas au système de bien fonctionner. Donc, le système de financement actuel doit être totalement revu pour permettre au mécanisme de bien fonctionner. Madame la Présidente, je sais que j'ai 2 minutes. Il faut aussi réfléchir sur la manière de parvenir à une plus grande interaction entre les systèmes des droits de l'homme et les institutions des droits de l'homme des régions. Vous avez, pour prendre un exemple concret, la Cour de justice de la CEDEAO qui a plus de légitimité que la Commission africaine des droits de l'homme. Reconnaissons-le. En moins de... La Cour de justice de la CEDEAO a commencé à fonctionner en 2007. Entre 2007 et maintenant, elle a une jurisprudence plus fournie que la jurisprudence de la Commission africaine qui existe depuis 1986. Cela vous montre à quel point il y a une nécessité de voir comment les systèmes peuvent s'entraider, comment les systèmes peuvent travailler ensemble. D'autant plus qu'il n'y a pas de hiérarchie. Rien n'indique que la Cour de justice de la CEDEAO est inférieure à la Cour africaine des droits de l'homme. Donc, vous voyez que de ce point de vue également, il y a beaucoup de choses à faire. 2 derniers points. Cette réforme a aussi impliqué une réflexion autour de la manière de choisir les membres d'un mécanisme. Et choisir les membres des mécanismes, c'est un élément essentiel pour le bon fonctionnement. Parce que la crédibilité d'une institution dépend du niveau élevé de compétences, de conscience au niveau du travail, mais aussi d'éthique des personnes qui sont chargées de diriger. Et de ce point de vue, la manière d'élire les juges, la manière d'élire les membres de la Commission africaine ou les membres du comité est fluide. Vous savez que la Commission africaine des droits de l'homme a eu un membre qui n'a aucune qualification juridique. Comment peut-on accepter cela si on veut vraiment s'assurer que les droits de la personne humaine soient respectés? Donc, de ce point de vue, il y avait un élément important à jouer. Dernier point, et madame, je vais vraiment terminer avec ça pour conclure, c'est la mise en œuvre des décisions. Un système n'est effectif, un système n'est efficace que s'il donne des résultats. Et il donne des résultats lorsque les décisions, les recommandations que ces mécanismes-là font, ces recommandations-là sont non seulement acceptées par les États, prises en compte dans les actions que les États sont menés, mais aussi s'imposent aux institutions des États. Le meilleur exemple que je peux vous donner, on est en Tanzanie, siège de la Cour africaine des droits de l'homme et des peuples. La Tanzanie a ouvertement dit à la Cour africaine par courrier qu'elle n'appliquera pas les décisions de la Cour africaine. D'une certaine manière, c'est une insulte au système. Je pèse mes mots. C'est une insulte à l'intelligence des personnes qui sont chargées de mettre en œuvre ces trucs. Mais c'est également un manque de considération pour les Africains que nous sommes. Nous tous, vous Tanzaniens, vous participez au financement des activités de la Cour par tout ce que vous faites. Et voilà un État qui dit, je ne respecte pas les décisions de la Cour. C'est-à-dire, tout l'argent que vous donnez, ça ne va servir à absolument rien. On a besoin quand même de revenir à la raison, de revenir à la réalité, de faire en sorte que ce système-là fonctionne. On n'a pas 1000 systèmes, chers amis. C'est le seul système qu'on a. Quand les États élaboraient ce système, on n'était pas présent. Mais on doit s'assurer que ce système fonctionne. Et que ce système fonctionne pour nous, fonctionne pour nos intérêts et permet de protéger la vie et la dignité humaine. Parce que sans vie et dignité humaine, la vie n'a pas d'intérêt sur cette terre. Et donc, nous devrons travailler sur ce processus. Et je terminer en disant que tout ce que je viens de vous décrire est un processus qui est dirigé par les États. Pendant toute la réforme du système, en aucune manière, je suis là devant des représentants d'ONG, de centres, aucune organisation de défense des droits de l'homme n'a été sollicitée pour avoir son point de vue. Aucun réseau d'organisations n'a été sollicité. Même les réseaux des institutions nationales, qui sont quand même des émanations des États, n'ont été consultés pour qu'ils donnent leur point de vue sur ce que sera le futur du système. Donc, vous voyez qu'aujourd'hui, on est à la croisée des chemins, on est au bord d'un précipice. Si rien n'est fait, notre système va s'écrouler. Donc, il faut que nous nous relevions, que nous reprenions nos forces et que nous fassions tout pour que ces systèmes-là existent. Juste pour vous avertir, si on n'a pas de système de protection des droits de l'homme pour nous, quel que soit son niveau d'inefficacité, ça va être la mort pour nous tous. Nos États vont faire ce qu'ils veulent, où ils le veulent et quand ils le veulent. Et vous savez que quand ils le veulent, ils peuvent massacrer, ils peuvent faire n'importe quoi. Donc, travaillons pour que tout soit mis en œuvre, pour que dans cette réforme, on ait un système qui reflète notre ambition de réaliser l'Union africaine, de réaliser l'intégration africaine et de faire en sorte qu'en Afrique, comme partout dans le monde, la vie et la dignité humaine soient respectées. Je vous remercie.
Brother Ibrahima, for that very elaborate presentation. I used to work in the women movement for many years. And what we used to do, we never waited to be asked anything. We used to study what was happening globally, and we would consult ourselves and would raise issues, would write to different institutions and give them our views even when they didn't ask. Sometimes they would not take our views seriously, but along the line, they would see our point and they would call us to the table and ask us, what did you have in mind? As I call the next speaker, I would like to know whether civil society have written to the reform team directly and voiced some of the issues that are being raised here. Because those of us in the system will be able to do it representing our organs. but the civil society are out there looking from outside and can be able to actually give very useful information to the reform team. And I think before we finish this panel, I hope we'll be able to check if we have done that, and if we haven't, isn't it maybe this, after this panel, civil society could come together and put something together and submit it to the reform team, including President Kagame, if you so feel strongly about certain issues. Thank you very much for your presentation. I'd now like to call on the next speaker. Advocate Don Dare is going to tell us about the accessibility, independence, and an effective African court. You have 7 minutes.
Thank you, Commissioner. I will be courteous, but I will be frank. And some may not like it. And I'll take one of the 7 minutes you've given me, Commissioner, before focusing on how we can reform the court. Is there an echo? To just look again, as Ibrahim has done, a backgrounding to the reforms in general. And I won't go into detail, but as Ibrahim has said, there have been various attempts or various exercises to reform what we have, even post the transition from the OEU to the AU. You didn't mention it, but there was a whole process kicked off by President Gaddafi in 2010 to 2012 of transformation of the African Union Commission into the African Union Authority, which was truncated by the North African Spring. And you've correctly pointed out that this current iteration began with the Obasanjo report, the report on financing the AU. And part of the irony is when Obasanjo presented his report in 2015 on how we could finance the AU, that's when the states began the dialogue that, but if we give you more money, you must show us value for money. And that's what kicked off the Kagame reports. And in the end, they've reformed everything except implement the Obasanjo report on how we should finance the AU, which is why even the reform now is being financed by donors. The post-2016 process, the Kagame process, has been a classic manifestation of how not to reform an institution. I know you gave us a challenge, Commissioner Leith, and we'll take it. But even giving us that challenge does not upend the order that there's a duty bearer and there's a rights holder, and that the obligation to consult the citizens is there in the Constitutive Act. So it's not a favor being done for that we have to beg. So much as we must organize ourselves, that must be remembered. The Kagame team, when they first started out, they started out by locking everybody, including the AUC Commission staff itself. They said, we're going to reform you. We don't need to talk to you. We know what's to be done. You know nothing. We're very clever in Kigali. We'll come with the perfect answer for everything. So it's not just citizens who are not involved. Even the staff have been barely involved, and the staff union has been complaining throughout. The underlying preoccupation with the reforms as designed by the states when they kicked them out was supposed to be a rationalization of what exists. But it has actually ended up being an obsession with downsizing. So it doesn't really matter whether you rationalize, because sometimes rationalize means you put in more resources, like Ibrahim has said. So the preoccupation now seems to be downsizing. So we end up with a schizophrenic situation, where we have Agenda 2063 with very lofty aspirations and very comprehensive 10-year plans facing in this direction. Then the resources with which to do it, financial, technical, human, are going in this direction. It's schizophrenia. It will just not work. So let's problematize now the current phase of the report, because there's that earlier phase, and the current phase, as Ibrahim has said, is now the 782-page report from Deloitte. And there are issues of ethos, issues of process, issues of substance, and issues of effect. Ethos. How do we let a neoliberal capitalist institution reform a Pan-Africanist institution? A Pan-Africanist institution that has a profound history and a profound politics in the past of fighting colonialism, in the present of fighting neocolonialism, and in the future of campaigning to reform the global political order, the global financial architecture, the global peace and security architecture, the global trade architecture. We're a campaigning organization, we're a protest organization. but we're being reformed by a neoliberalist body, which is benefiting from that which we're fighting from. So literally what we have is IMF-styled reforms, structural adjustment programs. That's the best that Deloitte can offer to the AU. Process, as I said, citizens were left out, and it shows. I'll show you why, because of the huge gaps you'll see in the report, even if you just focus on the African human rights system part. Substance, the content of the reforms, therefore, have received mixed responses. A few things you can say are good, you can't say they're not. The whole idea of a coordinated media summit between the AU and the REX, I personally find that useful. But I'll focus mostly on the ones through the African human rights system. Effect. The effect, especially in Addis, has been a hollowing out of the bureaucracy of the AU, especially at the AU Commission, but also in many other organs and institutions. If you undertake a head count now in Addis, many of the units are at half the capacity they were in 10 years ago. We now have, I think, like 2 peace and security analysts. In the conflict early warning system, we had 8. Conflicts are becoming more complex. Climate has entered. Terrorism has entered. Mercenarism has entered. But we are scaling down. So you have 2 people trying to cover 55 countries, 6 regions, 6 major languages in a complexifying. It will just not work. As a consequence, a lot of the states then have adopted a wait-and-see attitude. And this wait-and-see attitude is why even ratification of legal instruments have gone down, because they want to know, where does this go? What does this mean? Should I bother ratifying something that's going to be abolished? Focusing now on the chapter that deals with AHRS, it has actually only mostly talked about the court. The section is titled Judicial, Human Rights, and Legal Organs and Bodies, but the report deals with only 3 bodies: the African Court on Human and People's Rights, the African Union Commission on International Law, and the African Union Advisory Board Against Corruption, which the report itself calls On Corruption, despite the fact that this was changed by treaty. The report does not talk at all about the African Commission on Human and People's Rights. It does not talk at all about the African Committee of Experts on the Rights and Welfare of the Child. And in the section that deals with judicial, human rights, and legal organs and bodies, it doesn't talk about the role of the AUC, which is a major player, including as the host of AGA. In fact, I don't think the report mentions the word AGA at all, the African governance architecture, not at least in this section. On the part even involving the court, no court user was consulted, none at all. Clearly they came to Arusha, and clearly they spent quite some time with the court, because substantial parts of that chapter are written by the court. We're down the road. We're the busiest litigator at that court. We have more cases at that court than anybody else put together who were not consulted at all. It is inconceivable that any consultant reforming any institution will not contact the stakeholders of that institution. It is purely inconceivable, even though we could have been more proactive. And it's also not enough to ask African citizens from the 55 countries that it's them that should organize themselves to go meet Kagame and his crew. Who's funding it? Isn't there an obligation? All other processes, AGA and so on, much as those that will be consulted will be a microcosm of the citizenry, they will call citizens. The AGA process has so many best practices: youth pre-forum, gender pre-forum, blah, 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 all funded by AGA. Why couldn't that have happened in these most important of things? The appendices to the report, very interesting, see that the consultant contacted but received no information from the African Committee of Experts on the Rights and Welfare of the Child and the AU Commission on International Law. I'll be very interested to know what exactly happened that happened. So when it comes to the recommendations, it does get some things right. It acknowledges the challenge of limited access by citizens to the court. Because as I said, it totally doesn't talk about the commission, doesn't talk about the Child Rights Committee. So it talks about the court. Limited access by citizens. It articulates the problem of Article 34.6. It articulates insufficient human, financial, and technical resources at the court. It does. It then recommends a rehashing of arguments that we lost in 1998, that pass a treaty amendment to remove Article 34.6. I don't know which states they imagine will do that, the ones we live with or others. Positively, it reiterates the amendment of Article 5 of the Court's Protocol to make the African Committee of Experts on the Rights and Welfare of the Child be able to access the court as of right, the way the Commission can. That was actually already the subject of an AU Assembly decision. It's just that it was scuttled in implementation by 3 member states. It acknowledges the challenges in complementarity between the court and the Commission. It also raises positively the issue of the non-operationalization of the Trust Fund for Legal Aid for the African human rights system. And it points out where the problem lies, that the chairperson of the Commission should have operationalized, that he has been reminded by the policy organs at least 3 times, and that he has failed and neglected to do so. They use more polite language than I do, but at least they point that out. And of course, it also raises the issue of non-implementation of the decisions of the court. But the report also gets many things wrong. It continues what I call the Addis attitude that Ibrahim has just talked about, of privileging the court to the expense and the detriment of the Commission and the Child Rights Committee. It makes value judgment about the court's efficiency. The court is very efficient, the court's instruments are very good, the rules are very good, things move quickly, but it doesn't demonstrate what methodology it used to arrive at that value judgment, especially because it didn't talk to any user of the court except the court itself. It says that there are no statutory or institutional links between the court and the Child Rights Committee. I mean, it forgets that ACDEG exists, the African Charter on Democracy, Elections and Governance, and that AGA exists, and that AGA has written rules. It also says that there's no statutory or institutional links between the court and the REC courts, forgetting that the RECs are part of AGA, and there's a legal instrument for AGA, and also that there's a protocol relations between the AU and the RECs. And of course, it fails to articulate properly the future iterations of the court, that we have a court of human rights, and we've got separately a court of justice that should be operationalized, that we've got a merger court that comes from the merger protocol, and ultimately a Malabo court. Anyway, the way forward, in my view, overall, the AU reforms have done more harm than good. So we just need a hard stop, a reset, and a fresh start. Should we want a softer landing to smooth people's egos, we can say at least a section touching on AHRS, African Human Rights System, is woefully incomplete, and it should be taken out, and we have a fresh discussion that especially includes the Commission, the Banjul Commission, the Child Rights Committee, and the AU Commission. The other thing I would say that it fails to recommend, and we should recommend and demand, that the African Court of Justice should be operationalized. Its ratifications came through in 2009. There's absolutely many of our problems, including unconstitutional change of government, would have been handled much more robustly if we had that court. So we should just demand that it be put in place. We should also demand, because the STC Legal and Justice, its rules of procedure, allocated a role to supervise implementation. So that should be operationalized. If there is anything to amend, it should be the rules of procedure of the policy organs with regard to elaborating a more elaborate process for election of the 11 judges, the 11 commissioners, and the 11 child rights commissioners. That may be amendment of rules. And yes, to accept your challenge, Commissioner Litha Musimi-Ogana, maybe we constitute ourselves to write the people's reform agenda and take it to those in power. Thank you.
Thank you very much, Don, for that truth to power kind of thing. I think you've raised certain issues. You have reminded us of the union government process. You've talked about participation, inclusiveness, and the type of reform that we are going through, and how overwhelmed we are by the process. Thank you very much. Now, before we go for the discussion, because I think these are very thought-provoking views you are getting, we have to listen to what effective civil society engagement with the African human rights system feels like, reflecting on ECOSOC. And our speaker is Dr. Japheth from Amnesty. The floor is yours.
Thank you, Honorable Commissioner, for this opportunity. I've been asked to reflect on the proposals that have been put in place by ECOSOC. And just as a way of preamble, ECOSOC, in full the Economic and Social Council, is one of the organs of the African Union that is established by the Constitutive Act. And it is one of the two advisory organs of the African Union. The other advisory organ of the African Union is the Pan-African Parliament. And ECOSOC serves as a civil society arm of the African Union. It represents the voice, the interest, and the values that civil society bring to the table. So essentially composed of 150 civil society organizations drawn from the national setting to the sub-regional setting and all the way to the Pan-African or continental setting, composed of 150 civil society at those levels and including 20 civil society organizations from diaspora. And its function really is to inject the voice of civil society and to represent civil society at the African Union policy-making table and spaces. Established since March of 2005, it is now 28 years or so old. But much of those 28 years, unfortunately, was spent by the ECOSOC in a process of establishing its procedures and structures. And it's only actually in the last few years that we have seen ECOSOC really now actively and proactively working now to inject the voice of civil society in the workings of the African Union with the establishment of the ECOSOC Secretariat in Lusaka, Zambia. And one of these ways that ECOSOC has started to work more actively has been its process of establishing a harmonized mechanism for the granting of consultative and observer status to civil society organizations in Africa. And this process was not activated by ECOSOC itself, but was activated by the Executive Council of the African Union, which in June of 2015 asked ECOSOC to develop a harmonized mechanism for granting of consultative and observer status to civil society organizations. And last year, in February of 2022, ECOSOC started that process by issuing a survey to civil society across the continent on what they would feel a criteria for granting observer status and consultative status to civil society would look like, and also to states and to organs of the African Union. The result is a draft that the ECOSOC has developed on a harmonized mechanism. So you may ask, why is there a need for a harmonized mechanism for granting observer or consultative status to civil society? For you to get an answer to that, you have to go back to 2005, when the Executive Council adopted their own rules and criteria for granting observer status to civil society so that they may participate in the activities of the African Union. And since 2005, there are very few civil society that have actually applied and been granted observer status under the 2005 rules developed by the Executive Council. Why? Because it says that 2/3 of the funding of organizations seeking observer status before the Executive Council of the African Union more generally must come from its members. Essentially, 66% of your financing as a civil society must come from your members. This presumes two things. One, that civil society organizations across the continent are membership-based, that they have members who contribute monthly, biannually, annually fees that contribute to the income and finance of the company, of the organization, which in most cases across the continent is not the same. Two, it then prohibits you having funding from external donors below 66%. The second thing that you must also take into account is the statute of ECOSOC itself. The Statute of ECOSOC itself provides that civil society organizations seeking to be members of civil society and therefore represent the voice of civil society to the African Union must have 50% of their income from members. So it actually almost copycats the resolution of the Executive Council, but reduces it and becomes a little bit flexible, but it says 50%. So that is why it has been so difficult over the 28 years of the existence of ECOSOC for civil society to access ECOSOC and be part of it. Many of the mainstream human rights organizations that we know across the continent have not been able to be members of ECOSOC. And then, of course, there are treaty-based institutions like the African Commission, the Children's Committee, that they have their own observer status mechanisms. And we know that for the African Commission, it has been the most robust and active in terms of granting observer status to civil society. And we know now there are more than 600 or so organizations that have obtained observer status before the African Commission. So the AU thought that there is a need to bring together a harmonized mechanism similar to the United Nations. But there are thorny issues that must be raised with this approach. One is the context in which the Executive Council asked ECOSOC to prepare a harmonized mechanism. You'll remember that in June 2015, it is in that same session that the Executive Council ordered the African Commission on Human and People's Rights to withdraw the observer status that it had granted to the Coalition of African Lesbians. So there was a broader issue about controlling who gets access, not just now in terms of the finances, in terms of the 2/3 and 50%, but also in terms of the content and the rights that you seek to advocate for. So the control of even the content of what the civil society organizations will be doing. Then secondly, of course, was now bringing independent institutions under the umbrella of a more restrictive criteria for granting observer status. Now, what ECOSOC has done is to try and draw a distinction between AU organs and institutions established under the AU Constitutive Act, and therefore those organizations will have a central mechanism through ECOSOC for granting observer status. So for AU institutions established within the AU Constitutive Act, the ECOSOC will be responsible for granting observer status according to a criteria created by the ECOSOC. However, for independent bodies, such as the African Commission and the Children's Committee, the proposals by ECOSOC is that these bodies, and this is an important point to make, that these bodies will retain their independence in terms of granting observer status to civil society according to their own criteria and according to their own needs. So on paper, the proposal presented by ECOSOC is a good proposal. However, the politics is that this proposal will go back to the African Union Executive Council and other institutions for approval before it becomes operational. And therefore, there is fear, and I think justifiable fear, that the Executive Council will try to bring their own rules of procedure as established in Decision 230 of 2006 and their own rules of procedure about funding, but also remember the context in which it asked the ECOSOC to develop these resolutions. So there might also be a control of the nature and the scope of rights that civil society act upon that could be easily undermined by putting this harmonized mechanism process through the political organs of the African Union. So there is a need for civil society, us that are part of civil society across the continent, for eternal vigilance in terms of following this process and seeing that at the end, whatever harmonized mechanism that comes out of the African Union process does not specifically undermine the authority and independence of independent institutions like the Commission and the Committee to independently grant observer status to civil society. Another way where you could see the mind of the African Union is in treaties, for instance, like the African Court Treaty. And I think it's important to mention this in addition to what Don Dare had said. One of the issues that has affected civil society is the ability to file advisory opinions before the African Court on Human and People's Rights. And this is linked to the Executive Council decision of 2005. The court protocol says that any African organization may request the African Court to render an advisory opinion on a specific issue. However, the African Court has narrowly defined what African organization means. And this was in the advisory attempt filed by the Center for Human Rights and the Institute for Strategic Litigation in Africa, where the African Court said any African organization recognized by the AU means an organization granted observer status under the 2005 criteria. So it locks out all of you organizations that have access to the African Commission, for instance, and have been granted observer status for the African Commission. The applicants in that case had made the argument that if the African Commission recognizes you, that should suffice as a recognition by the African Union more broadly, because the African Commission is a treaty body established under the auspices of the African Union. But the African Court threw that argument out, and therefore, the number of organizations that can actually file advisory opinions before the African Court are so few, and that's why Don Dare, for instance, is among the few that have been able to file advisory opinions because they have a memorandum of understanding with the African Union. But the majority of organizations across the continent cannot access the court more broadly under Article 34.6, but even now in terms of filing advisory opinions. So we should be very careful in terms of watching the reforms so that it does not further restrict access to these institutions through the harmonized mechanism that the ECOSOC is preparing. Thank you, Chair. That will be my thoughts for now.
Thank you very much, Japheth, for that very clear illustration of this question we put to you. I'm going to be opening the floor for questions, but before that, I have a question for you. The United Nations, ECOSOC, the Social and Economic Council, registers accreditation for all the NGOs that apply to the United Nations. It doesn't matter whether you are in Geneva, you are in Asia Pacific, and they have centralized that. And we are not complaining. We don't seem to be complaining. But when the AU says that it would like to centralize its accreditation, we are very annoyed. So I think that is my question to you. We are all looking for answers. We have many questions. So the floor is open. We'll take at least 5 questions, and we give every person asking a question 2 minutes or less, and please say whom you are directing your question to. So the floor is open. The day, and we at the high table will be very happy to be released, but I believe some serious issues have been raised by the presenters. I see a hand up there. I'm going to give you the floor. And this is a civil society forum. I am telling you, I come from that angle, civil society. It's the first time I'll be in a panel where civil society don't have questions. So I give you the floor for now. Yeah, I recognize you.
Yeah, thank you so much. My name is Ahmed Al-Tahir from Sudan, Darfur region. I'm a journalist and human rights investigator. I'm asking, within all these challenges that we have addressed it now, how long as African nations we are going to wait for an African mechanism to achieve justice and accountability for all these crimes within our continent?
Any other question? While we are waiting for another question, I have another one. Yes, I think from the 3 presenters, it's come out that not just member states and AU is depending on development partners. That is why ECOSOC members are not coming forward, because they are also funded by development partners. So I want to ask the panel, how can we, both government and civil society, weed ourselves from this donor dependence? That's another question. Yes, the floor is still open. So can I? Are we on air? So can I assume that those are the only questions we have, and give the participants the floor to answer any of the questions that have come up? Oh, there's another question. Yes.
Thank you so much, Honorable Commissioner, and thanks to the panelists. My name is Lloyd from the Center for Human Rights. I just wanted to find out, this issue of the failure to consult the stakeholders who use the African human rights system is quite disturbing. I just wanted to find out, maybe from the panelists, what should be the way forward now to ensure that if decisions are going to be made on the basis of the Deloitte report, that our views as civil society are going to be taken on board and into account. Thank you.
Thank you, thank you. Is that all? Can I close the, oh, there's one more here.
Okay. My name is Tasfa Meret Haile. I work for Africans for the Horn of Africa as the legal and advocate officer. I want to ask about there was, maybe you can help me, it was a request by the Committee for the African Child, and the court found that it doesn't belong to, to the African Union. How do you see the effect of that finding in terms of protecting the African child? Thank you.
Yeah, thank you very much. I hope, was that question clear? No. Can you please repeat your question?
Okay. The problem is, I read this a while ago. It was from the Committee of the African Child. And whether it was a communication or advisory opinion from the African Court, but the finding was such that the committee was excluded as from being part of the African Union. So I am asking the implication of that finding for the protection of the African child. Thank you.
Don has got that question right. So I think I close the floor now, and I asked there's the last one.
Thank you very much. Mine is not a question, but kind of challenging ourselves this side of the whole, the CSOs. We have heard that one of the key problems, key challenges of the African courts, the African human rights system, is lack of implementation of decisions of the court. So what we as CSOs, can we have something that we are going to agree upon that we are going to do to help in the implementation of the court system? That is my contribution. Thank you.
Thank you very much for those questions. I'm now going to ask the panelists to each take 2-3 minutes to respond to the questions that are, appropriately fitting within their presentation. I start with Japheth.
Thank you, Honorable Commissioner. I'll start with your question. Why is it that we get annoyed by the apparent attempt to centralize accreditation system in the African Union, yet we are not annoyed with what has been happening for decades in the United Nations. So, first, it is not true that we are not annoyed with the ECOSOC process. There has been problematic cases even within ECOSOC where states influence and object and stop the accreditation and granting of observer status or consultative status to NGOs within the United Nations system. They have gone further even in certain instances to stop civil society from participating in certain spaces. So we shouldn't proceed from the premise that the ECOSOC system is perfect and that African civil society are not annoyed or do not have criticism of that system. But secondly, we must see these two systems from their historical evolution. And the states that the behavior or the pattern that African Union and the African Union member states have created over the years. So I've given the example of the ECOSOC statute, the example of the Executive Council resolution. I've given the 2015 example of Executive Council direction to the African Union, but also even the decision of 2018 November about the reforms, where it specifically says that for AU summits going forward, participation will be strictly on invitation. And the result actually is that since 2018, civil society participation in summits of the African Union have completely, significantly reduced. So the question is, how do we trust the same institution that has since 2002, when it was established, been hostile to civil society, to now change their mind and become conducive and amenable to civil society? It is easy for us to trust, for instance, the African Commission on Human and People's Rights, because we have seen that since 1989 it has granted observer status to civil society almost automatically and more flexibly, of course, with a few exceptions that we have seen in the recent past concerning organizations that advance the rights of LGBTI. So there is a history that makes us apprehensive about African Union's approach to civil society participation. I think I will leave the other questions about a way forward and the Children's Committee to Don Dare. Thank you, Honorable Chair.
I'll skip Don and go to Anna Foster. You have listened carefully to some of the presentations that have been made and to the questions that we've been asked. Maybe you could help us with a few answers in 3 minutes.
Thank you very much. Thank you. Thank you very much, Madam Moderator. I don't believe a question was directed at me, but I'll attempt to answer Lloyd. I think there is need to strategize on the way forward by civil society. What civil society wants to see more is the holding of states to be accountable. We do not believe that the court has the ability to make courts accountable. We know already the court has challenges of having their decisions implemented by states, and it is very problematic at the moment. So as civil society, I think we need to sit down and put our thoughts together, get our act, and come up with perhaps a petition or even write contributions that we send out and make sure that the citizenry know that they have some of these issues of access at stake, and it might only be through our collective intervention that things might be addressed by the AU. Thank you.
Thank you very much, Anna, for that response. Now we give the floor to Advocate Dare.
Thank you very much, Commissioner. I just endorse, the points that Japheth has made, that when it comes to your question, and when it comes to the experiences of citizens with engaging various parts of the AU, especially the policy organs in Addis, there's been a history. But I'd also add that the Constitutive Act of the African Union is very different from the UN Charter. The explicit promises that the Constitutive Act makes for citizen participation is way, way more elaborate than anything in any UN instrument. The same is followed up by the African Charter on Democracy, Elections and Governance, the African Charter for Popular Participation in Development, the African Youth Charter, and so on. So we've got a completely different legal regime that they're obliged to follow. You've raised questions around how our states are funded and how civil society are funded. And I think actually these should be topics. I think that's a very good challenge for us, Commissioner. This should be topics for, I think, not just side sessions, but maybe mini workshops when we meet for the 78th ordinary session. Because for certain, the AU best practices have clear decisions around domestic resource mobilization that will triple the income of African countries and thus triple even the income of AU organs and institutions. We've got decisions around natural resource management, such as the African Mining Vision and its implementation plan and the African Minerals Development Center. We've got decisions and declarations and work plans around combating illicit financial flows. And even now, we're working on campaigns around sovereign debt and around how we can force the world, especially the Bretton Woods institutions, to freeze debt at periods of extreme crisis so that social services and public services are not imperiled. It is doable. And I think even on our part as CSOs, I think there's a whole movement now around African philanthropy. So there's a lot of research. For instance, colleagues from Dr. Becky Moyo and other colleagues from the Wits University are doing a lot of research and a lot of dialoguing around African philanthropy and actually convening African philanthropists so that hopefully that should change the space of how civil society behaves. But I think the most profound mind shift that is needed is with our governments. Because even if you look at the organizations that grant us money, and if you look at civil society in the global north, they are funded by the taxpayer. The largest funder of civil society in the global north is the taxpayer through government. So again, it's about challenging our government. On the question from the colleague from Sudan, the journalist and human rights investigator, like how long will we wait? I don't think we are waiting. I think a lot of work is going on, a lot of campaigning, a lot of advocacy, a lot of awareness raising and capacity building, a lot of strategic litigation and so on, and we are succeeding in many places. I think Commissioner Letha was giving us a reminder how, for instance, the African women's movement over the last 15 years have managed to shift a lot at the level of the AU and in many member states. So yes, there are places where we're still facing setbacks, but I think we really should energize ourselves by beginning on areas where we have succeeded, because there are many. On Lloyd's question on this failure to consult and where does that take us and how do we go forward, I think that's why for me, I try to coin the term the People's Reform Agenda in response to the challenge by the Commissioner. And that's precisely why we asked our colleagues from the African Court Coalition together, and we asked the Commission to agree to host this discussion, and not outside in the hotels where we do our business, but on the floor of the Commission, so that we could raise awareness amongst colleagues, and so that we could begin building the team together with the practical recommendations that we can come up with. Our own alternative for should be reformed. So that's precisely why we had this. And it's not only us, even colleagues from the African Civil Society Engagement Group have had, I think, at least 2 Zoom meetings over the last 2-3 months, which is how we're building our knowledge of where things are and beginning to think of some of the things that could be put in place. Tesfamret Hale's question was, I think what you're talking about is the advisory opinion that came from the African Court, which was based on a request by the Child Rights Committee. So the Child Rights Committee went to the court to ask the court that, would you allow us to file cases before you? Personally, I disagreed with both the Child Rights Committee and the court. I told the Child Rights Committee, you don't ask if you can be elected, just file a case progressively and take it. Then the court will be ambushed with the case. Then it will have no option but to give a decision. But if you give them that option and they take the lazy option, they'll tell you no. You know, it's like when you walk into, I like my wine. So sometimes you've walked into a pub at injury hour. It's about closing hour. What will your first question to the barman be? Will it be, are you open? Because if he says no, now you have to struggle for him to at least give you one. But if you arrive and say, give me a glass of wine, then the onus is on him to say, actually, no, I can't, but maybe I'll do you a favor. So I disagreed with the committee for asking that question, and I tried to beg them not to ask. But once I'd asked, we did an amicus and tried to tell the court, read African legal instruments around human and people's rights purposefully, like you've done in other cases. And if you do so, then you'll see that what the commission has, the court has. But they decided, the Child Rights Committee could have. But they decided to take the conservative line, and that's when in their decision, they then also recommended that the article that gave the commission the right to file cases directly, which is Article 5, should be amended to explicitly also mention articulate the Child Rights Committee. And then when this was taken to the policy organs actually agreed. And draft amendments were done, and they were even taken to an STC meeting, the Specialized Technical Committee for Legal and Justice. I think this was 2017 in Togo, 2017 or 2016. And some states scuttled it by saying that the drafting could be better. But I think they've just been overwhelmed. The STC has not, or the legal council has not brought it back. But there's a clear, I think 2 or 3 decisions from the assembly saying this should be done. So it's about implementation. And finally, I think my eyes are not very good, but I think that was Council William Kibuyo, but I'm not sure. His was more of challenging ourselves on implementation. And to say that actually we held an event on that, Palu and Partners held an event on implementation on Friday. One of the recommendations, or one of the resolutions of the participants was to actually form a continental coalition on implementation. And then we're going to also have national coalitions on implementation. So we work much more robustly as the broad diversity on civil society to push for implementation. So that was done. The same way our colleagues from Center for Human Rights and others convened us on Saturday to discuss a much more robust participation in the election process for judges and commissioners and experts. And again, as civil society under their leadership, we arrived at some resolutions and some steps forward of how we can be more proactive going forward. Thank you.
Thank you very much for those excellent responses. In conclusion, I would like to say that the reforms, like the participants, the panelists have talked about, were meant to deal with fragmentation, address fragmentation, duplication of resources, lack of coordination, and reliance on partners, among other things. And I think after listening to the 4 panelists, we have got a lot of content that civil society can use to write to the Reform Committee to express themselves and voice their view, how they feel that the reform should have gone. My request to you is take all your presentations and convert them to a petition, if you wish, so that you don't lose those very good points that you have. And then send this to the Professor Mukoko's team and send another one to President Kagame. Let them know how civil society are feeling and how they feel, because if you don't, then you cannot criticize them. I know we are not very many here, but it reminds me, and this is my concluding remarks, it reminds me when I used to mobilize African women participation in the United Nations processes. And it was very difficult because in New York, it was not easy to bring women from all over. And at some moments it would be very sad because the hall would be like half empty. So my American friends told me, Lita, don't worry. It's not the number in the room. It's whether we are in New York Times tomorrow. And it happened many times that the few issues that we touched on would be in New York Times. And so I hope this can be in our New York Times, and that is the reform team. I thank you very much for your patience. I appreciate all the views that have been expressed. I think we had a very good panel. They brought up very good issues, and we thank them dearly. Please convey our gratitude to our brother, Mr. Kane. He had to leave earlier, he excused himself, and we just want to say thank you for being with us and staying this late. I would like at this juncture to hand over the microphone to the facilitator, but on my side, I think would like to say that the official segment of this panel has been concluded. I thank you.